Ready? Start. We are unable to agree to this proposition for the simple reason that the said government order spells out that if appointments are made in excess of the posts advertised, then such appointments will be saved to a certain extent. Stop. In the instant matter, he was never appointed either in excess of the sanctioned posts, excess of vacancies, or in excess of the posts advertised for selections. Stop. The government order only speaks of appointments against posts in excess of that which have been advertised. Stop. The same does not envisage a post in excess of the sanctioned strength. Stop. He has himself claimed appointment against the post that was held by him who had been dismissed from service. Stop. In this contingency, the government order does not come to his aid at all, and consequently this argument is rejected. Stop. The only question that now remains to be examined is as to whether the payment of salary to him was against a post within the sanctioned strength or not, for which he claims his appointment. Stop. Para. We would have ourselves recorded findings on the material available on record, but a major hurdle that has come in our way is the non-impediment of the Sanskrit University Varanasi as a respondent in either of the petitions. Stop. We have our doubts about their non-impediment by both the rival contenders, as the real picture would have emerged with the process of approval undertaken by the university against a sanctioned post and available vacancy. Stop. The version of the university therefore is not available before this court, but the authorities ought to have proceeded only after putting the university to notice and calling for the records from the university. Stop. It is evident from the facts that this exercise was attempted by the district inspector of schools while passing the order dated 2012-2001, which indicates only an unsure status of the approval of the appointment of him on the verification of the approval dated 5/8/1992. Stop. The aforesaid doubt has been discussed by us herein above. Stop. Similarly, in the case of the earlier order of the Deputy Director Education dated 31/12/2013, which is impugned in the first writ petition, does not reflect the correct picture after a proper verification of the facts. Stop. In this background, we find that neither the order dated 31/12/2003 can be sustained, nor the order of the state government dated 16/7/2015 can be sustained. Stop. For the same reason, the other intervening orders of the district inspector of schools, the deputy director education, or any opinion expressed by the authorities can be stated to have taken notice of all the facts and verified it from the Sanskrit University before arriving at any conclusion. Stop. We have already made observations herein above on the issues raised by the counsel for the parties, and we therefore now expect the authorities to proceed only after taking into consideration the aforesaid observations and pass appropriate orders, as it involves the fate of the continuance of the rival contenders and their claim to salary stop over.